Okay, it is 3 o'clock, so we were going to call the Senate Judiciary Committee to order. Welcome. Just to let everybody know this is going to testify. We're being televised. Madam Clerk, call the roll. Establish quorum.
Chairman Jones?
Here.
Senator Shoemaker? Here. Senator Rocca?
Here.
Senator Kolbeck?
Here.
Senator Bida. Mr. Chairman, you have 4 members present. There is a quorum.
Very good. I'll make a motion to adopt the September 12, 2017 committee meeting minutes. Without objection, they are adopted. And the first bill up is Senate Bill 527, introduced by Senator Casperson and Senator Tanya Shoemaker. Come on up.
Thank you, Mr. Chairman, for having us present Senate Bill 527 to the committee. And I guess I'll start, if that's okay. That's fine. This was brought to my attention through a constituent of mine that was working towards becoming a foster parent and thought that the parameters around that had a stipulation that reflected on ownership of firearms as being part of the requirement or not requirement to being able to be a foster parent, and that was quite concerning to him. And as we looked into it, we also got concerned that our Second Amendment is involved in this, and that it was becoming potentially a stipulation of being able to be a foster parent. But I'm going to have Senator Shoemaker. She can follow through with some of the things. But let me just, I've got an email from my local sheriff. I come from Delta County. Ed Oswald is our local sheriff. He's well respected, and I think his email really sums up why we might have some problems here. And he is our sitting sheriff, and he's also a foster parent, and he's informing us that he cannot carry when he's off duty. Everything changes for him because of being a foster parent. With his ability to carry his firearm. And I just believe, Mr. Chairman, there's something gone wrong here when our own local sheriff, who was duly elected by the people, somehow is entrusted to be able to handle his firearm even though he's a foster parent. Like somehow that changed him. And I think, others will testify, but for me that's a huge concern. I will tell you, as we move forward with the bill, there's been some concerns shared with me of interpretations of how the bill is really written, and I would just ask that the committee ask good questions, and if there aren't changes that would need to be made, we need to do it right. But I think we need to protect our rights, and we shouldn't be looked at as somehow different because we own firearms. And it appears to me that that particular issue is being done here. So thank you, Mr. Chairman.
Thank you, Mr. Jones, or Senator Jones. I appreciate the opportunity, and Senator Casperson covered it to a pretty good extent. I would just add that this constituent actually is a former resident of my district, moved up to Senator Casperson's district, and has a number of friends who brought this aware to me through social media. And I just thought it was an outrage that the Second Amendment would it makes no differences between law-abiding parents on one side versus foster parents. And so this rule, I feel, is an infringement upon foster parents' right under the Second Amendment. And so that's why I co-sponsored the bill with Senator Casperson.
Wonderful. I heard of this case, I understand, is from Gogebic.
Ontonagon, Gogebic County, up in the far west end of the Upper Peninsula.
And isn't it true that people commonly carry there to protect themselves and their children from bears and other creatures of the UP? I mean, I would think that we would want them protecting the children.
Yeah, I won't even go any farther than that because they probably use it to protect themselves from other things. But you're exactly right, and we joke about it a little bit. But our Second Amendment rights and ownership of firearms is important to all of us, especially up in the Upper Peninsula because of everything that we're involved with up there with hunting, fishing, and the protection. You mentioned, you joked a little bit about the bear, but the wolf has certainly changed the dynamics of the Upper Peninsula, and people that used to go casually walking in the woods don't do so anymore without carrying firearms in many cases. So Things have changed, but it's also kind of a philosophy, Mr. Chairman, that there's just some people that just believe firearms in and of themselves are bad, and so there's a huge concern, and we should all have a healthy concern for firearms and treat them respectfully. But in this particular case, to go to this level, it seems to me that there's a better way to do this. And like I said, there's been, and you'll hear committee or you'll have testimony in committee of some other concerns that could be involved in this. So I hope that we work together to get it right. But I'll give you an example of some of the things I'm hearing. It potentially could block a foster parent from going to a fire range with a foster child and go to a recreational opportunity with a firing range. Those of us that have firearms look at that as an opportunity in a recreational sport, just like we'd look at going biking, hiking, and ORVing and snowmobiling. And that's how we look at the firearms that we have. It's not something to fear. And so with foster kids, if I'm trying to be a mentor to them, and that's part of my life, I see no reason why a foster parent would somehow be restricted from that. So I want to make sure that whatever we're doing here, we don't do things like that, and we don't allow a policy within a department to do something like that as well.
I understand in the case in UP, this was a grandfather.
Yes.
And so I suppose we carried this to the extreme. A grandfather couldn't take his grandson hunting.
Well, and that's the concern here that some have, that maybe even what we're trying to do today with the language we have could potentially do that. And that's why I want to make sure as we move forward, we do not do that, because that makes no sense, absolutely no sense. And those of us that enjoy those great outdoor activities, to me, we've got bumper stickers about hunt game and not hunt for your children. In other words, keep your children with you and teach them how to do those things. And it's a great opportunity to get out in the great outdoors and enjoy it. So because of the gun aspect of it, I think some would not recognize that as an opportunity, as a teaching moment for even a foster child, and I think that's wrong.
Well, I can tell you as a hunter and as a former sheriff, I would much rather young teens were going out hunting with their grandfather than sitting at home playing violent video games and learning bad practices. Do we have any other questions? Senator Colbeck.
Yeah, thank you very much. I appreciate the legislation, appreciate the idea that we're going to be providing restoring the right to bear arms for foster families. But I was wondering, in your preparation for this bill, did you do a comparison between what the guidelines would be for any adult bearing arms in a home versus what's being proposed here for foster parents? Because my concern is, in a foster home, I mean, I don't see why we'd have any different rights for them as opposed to anywhere else. And I'm just wondering, as a result of this, do we still have a disparity?
Yeah, that's a great question, Senator, and that's another concern that has come up out of this. A couple things there that I think are important for those of us that are gun owners, that I think we need to be careful to at least recognize if we're placing kids in a foster home. Traditionally, it's not maybe in every case, but in a lot of cases, it's because there's been something that's gone wrong, and these kids have come from a situation where things really weren't normal for them. And so I think people are concerned, and they're asking that question. It's not so much that the parent or the foster parent has any problems whatsoever. It's that maybe the child could have some problems. And if you don't at least address the idea or the notion that we need to be responsible and secure the firearms, some could disagree with that. Now, the argument I'm hearing is that if you're responsible and you're a gun owner and you're a law-abiding citizen, that's already taken care of. So that's the quandary we're in right now, to balance that out and decide whether or not it's needed or not needed as far as that part of it. But I will tell you that there are people that are concerned about it, knowing the circumstances. They're not completely normal in the sense of sending normal kids in a normal family setting. I have 4 children. All my children knew where my guns were, and they also knew where the ammunition was, and they weren't together, but they knew where it was. And I never had a problem or concern with my children, but I'm also not a foster parent, so I can't speak to you that that somehow that setting is just as normal as what it was with my own children.
Any other questions? Seeing none, thank you.
Thank you, Mr. Chairman and committee members.
Now invite up Tom Lambert from Michigan Open Carry.
Let me start off by saying we absolutely support the intent behind this legislation. I think the intent is wonderful. We wholeheartedly and enthusiastically support the intent behind this. However, we do believe that there are problems with the specific language as introduced. Senator Casperson did a great job talking about a few of them. If you look to subsection 4, if you just want an example, there's a few different options in there. Not options, but it says that when you're carrying a firearm, you have to follow all of the following. Effectively, the 3 options are keep the firearm in a holster or similarly secured case, carry the firearm in a manner where the foster child doesn't have access to it, or where it's in the possession and control of the adult, or the 3rd option is it's in a case. So you have to keep the firearm holstered or encased. You have to make it so the foster child has no access to it or control of it at all, or you have to keep it secured in a case somewhere else. This leaves no option whatsoever for a foster child to be presented with a firearm for a lawful purpose, such as education, such as hunting, such as training. As a certified instructor myself, I'll even say for those that may oppose firearms in the home, I say that every child should be instructed on the safe handling of a firearm in case your child goes to a friend's house where they do keep firearms. Education is very important. I think the sponsors agree that education is very important, and I do believe that the extent to which this does create problems is absolutely unintended. I enthusiastically look forward to working with the sponsors going forward to fix this language and hopefully get something that does meet the intent of this legislation so we can get the problem cleared up. Let me just end with saying, if I had a choice to take either this language as introduced or the departmental policy that's currently in place, I would choose the departmental policy. That's, I hope, underscores the gravity to which I believe this current language is a problem. If this language were to pass, it would codify much of the policy as it currently stands. It would be very hard to fight. The policy itself, I already believe, is illegal under current state law in many different ways, dealing with possession of a firearm. The policy requires all handguns to be registered, and then they want serial numbers to be presented to the department, even though this body, as well as the House, just a couple years ago, passed legislation declaring firearm records to be confidential. So right there, I already believe they, in many ways, are already violating state law. Again, we oppose the language as introduced, but are very, very supportive of the overall intent behind it. Thank you for your time. I'd be happy to answer any questions.
Okay, I can tell you that we posted for a vote today, but we're going to hold it up for a week so the sponsors can refine the language a little bit more.
Great. I look
Any questions?
very forward
Senator
to
Kovac.
Yeah, and I just wanted to explore a little bit the ideal provisions that you would see in legislation of this type, because we all share the same purpose, and this is one approach to going off and fulfilling that purpose, but how would you redefine it?
Thank you for the question. I think it's an excellent question. You mentioned disparity earlier, whether or not this language creates a disparity between current law for everyone else and foster parents, and I do believe it absolutely does. I would support language that affirms the rights and privileges of foster parents, or conversely limits the authority of the department to regulate beyond state law. I already believe they are field preempted under state law from regulating, but that would be a fight that we would unfortunately have to flesh out in court. But if we were to pass legislation, it's cheaper, it's quicker, we can help people right away. And just to reiterate, I would like to see something that affirms the rights and privileges of foster parents so that we treat them the same way as everyone else. And if there is a concern with, well, this should happen for safety's sake, then I would say that concern should be debated for everyone, not just foster parents.
Okay, thank you.
Okay, thank you.
Thank you.
Now I invite up Brendan Bedreau of the National Association for Gun Rights.
Thank you, Mr. Chairman. I won't, to save time, I won't repeat a lot of the same things that Mr. Lambert has already covered. As the bill is currently drafted, We believe, again, as Tom just stated, that the intention behind the drafting of Senate Bill 527 was very noble. Anyone who's willing to foster a child in need is worthy of our praise. We're concerned about the disparities in Senate Bill 527 when it comes to treatment of a foster parent versus any other law-abiding citizen in the state of Michigan when it comes to their right to keep and bear arms. So we would appreciate the language also being adopted to affirm and protect the rights of foster parents to keep and bear arms. We don't believe they should be treated any differently. Gun owners should not be treated any differently under the law in this instance. I know right now in Michigan we have a shortage of foster parents, willing foster parents. Michigan Radio covered that back in August. And I fear that if the bill as currently drafted may have a chilling effect, just as the current HHS policy has on the willingness of foster parents to foster a child. So as it's currently drafted, our organization does not support it. We would support it if we were able to address the issues that I cover in my written testimony that everyone has there, as well as a letter that I gave to the sponsors as well.
Okay, thank you. Any questions? Seeing none, thank you.
Thank you.
Art Tom of the NRA from Fairfax.
Mr. Chairman, committee members, I appreciate your time and the opportunity to testify in front of you today. Although I disagree with some of the testimony in that it takes away the ability to allow a foster child to learn to hunt or to target shoot, I do agree that there could be some amended language. One of the things that may be the best opportunity or the easiest would be for the Senate committee members to take a look at and reference House Bill 4955, which was just introduced a few days ago. It's a pretty quick and concise way to do it. That said, again, I'm here representing the 160,000 Michigan members of the National Rifle Association, parents, grandparents, and potential parents and grandparents across the state, and here to speak on the absolute necessity of a bill like Senate Bill 527 or, as referenced, House Bill 4955. I'll start with a powerful quote. If you want to care for your grandson, you'll have to give up some of your constitutional rights. For those of you who may not be aware, that quote was to Mr. William Johnson from a Michigan Department of Health and Human Services employee. He was also told that there would not be a power struggle. I don't know if any of you are parents or grandparents, but consider, if you will, walking into a state agency to pick up your child, and due to being a lawful citizen, a concealed carry permit holder in this case, the bureaucracy demanded not only your papers, but further demanded that you make record of all your lawful possessions. This is the most blatant example of government overreach that I can see. This time it's guns, but what's next? What happens if you, the leaders trusted and hired to represent and protect your people, allow this to continue? What happens if you don't send a clear message that this nonsense will not be tolerated? What other constitutional freedoms will we allow DHHS to strip away at their pleasure? Should Michigan parents vote how DHHS demands or not be found suitable? Maybe they should only express their views or opinions the agency finds favorable. According to the Michigan DHHS website, there are approximately 14,000 children in foster care in Michigan. On average, over 300 are waiting with no family. 300 children in the state of Michigan with no family, and DHHS makes a statement to Mr. Johnson that he must choose between his constitutional freedoms and his grandchild. I hope you consider Mr. and Mrs. Johnson, as well as the parents and grandparents throughout Michigan, and through your vote on this legislation, send a clear message that when a bureaucracy looks at you as representatives of your people and says there will not be a power struggle as leaders of this great state, I trust you will step in front of your people, look back at them, and say, "You're damn right there won't be." Thank you. I'll stand for any questions.
I don't see any questions, but I can tell you that I have a great deal of experience with foster children. One of my children has taken in over 25 different children. 2 were adopted. They're now my grandchildren. I became the foster grandpa for all of them. And some of them did have mental disabilities from the abuse, the drugs and the beatings and the things that their parents had done to them. Horrible cases. But there were some exceptional young people, teens, that had just had a troubled parent. And I had a couple of them ask me if they could go hunting. I didn't take them hunting. I would have asked permission from DHHS had they been with my child long enough as a foster child. But they found a half-brother, and the state's policy is when you find a family member to move them to the family member. So eventually they moved on. I still see these young people. They're now adults out in the community. They're doing very well. And I do think the foster system can work. But also, as a former sheriff, I can tell you I would much rather have them out hunting with their foster grandpa than watching violent video games and learning how to kill police officers and all the other horrible things we have out there. So thank you for making the trip. Appreciate your testimony.
Mr. Chairman, I agree with you. Thank you, sir.
Now invite up William Hawley. No city? William Hawley? Escanaba? Yes. Thank you.
Good afternoon. I do appreciate this opportunity to speak before the committee. My name is William Hawley, and I'm currently the president of the Delta County Gun Owners Association in Escanaba. Our organization is committed to promoting the safe and legal ownership and use of firearms as expressed in the Second Amendment to the Constitution of this country and guaranteed by the Bill of Rights in Article 1, Section 6 of Michigan's Constitution. Upon getting our copy of Senate Bill 527, our board of directors met and were reading it with the hope of supporting it. And we were, as other people here today have said, are very supportive of the fact that the principle is to protect these rights of the foster parents to have firearms in their possession. However, we just don't feel that at this point that we can support the bill. We also took this bill to our general membership, and the membership unanimously agreed that the way that it is written today doesn't protect the right of foster parents to possess firearms, but actually puts these current policies into law, and it further restricts their rights to have arms. We believe that Senate Bill 527 must be amended so that it affirms and protects the rights of foster parents rather than restricting them. In my mind, something so simple as saying Michigan Department of Health and Human Services shall not institute any policy regarding possession of firearms as contradictory to the Second Amendment to the Constitution or the Bill of Rights in Michigan removes that policy from enforcement and prevents future restrictive policies. I realize that that might be very simplistic, but that's kind of how I feel about it. Let me give you an example about this. Senator Casperson also talked about it. But yesterday I was talking to the Delta County Sheriff and Ed Oswald, and that we were coming down here. He offered his story and asked me to relay it, which I won't try to repeat too much of it because Senator Casperson already did. But Sheriff Oswald is very opposed to these regulations as they restrict him from performing his job as a law enforcement officer and protecting his family. I personally feel that making these regulations into law further restricts the rights of foster parents who wish to exercise their rights to bear arms. This is just Sheriff Oswald's case is just one example of how restrictive this current policy is. And if it's enacted into law, I feel that it would prevent the foster parents from exercising their rights to bear arms and protect themselves, their family, property, and foster children that they're providing homes for. When Senate Bill 527 is amended so that it affirms and protects the rights of foster parents rather than restricting those rights, Delta County gun owners would be more than happy to support this bill. Thank you.
Well, there's no vote today. I assure you that there will be some refinement of the language.
Thank you.
Seeing no questions, thank you. Robert Peterson. I didn't know you men were together. I would have brought you up together.
That's all right. That's okay. Although we could use a little moral support, this is our first trip to Lansing to do this. So, I am Bob Peterson. I'm with Delta County Gun Owners Association. I'm a board of directors, co-founder, and former president. I'm going to try and cut this down a little bit as best I can because everything's been said and we're repeating it. The one thing we feel is a person's rights can never be protected by regulating them. People that make the conscious decision to become foster parents are subjected to a rigorous battery of background checks, interviews with themselves, as well as their friends, their family, by the Department of Health and Human Services. Their homes and property are inspected and often require updating, sometimes at significant cost. After their initial licensing process, they are required to open their homes periodically to inspections by Health and Human Services. They do all this to offer their homes to less fortunate children. Health and Human Services make sure that the applicants are serious and responsible citizens capable of providing a safe environment for these children. Yet after going through all the entire process of becoming a licensed foster care provider, not to mention if they are gun owners, they are required to have background checks and when purchasing handgun, along with training and additional background checks to receive their concealed carry permit. They are then told they are not responsible enough to keep their children safe by having a gun in their home, nor are able to exercise their rights as Americans and Michigan citizens to keep and bear arms. HHS, a bureaucracy, feels the need to place extra and onerous regulations on natural rights not given to us by our government, but protected by our state Bill of Rights and our Michigan Constitution, United States Bill of Rights and our Michigan Constitution. SB 527 in its current form, if followed to the letter, would not only infringe on the foster parents' right to keep and bear arms as they see fit, but would hinder their ability to protect themselves, their family, their property, and the very children they are charged with taking care of. This bill would also prohibit the foster parents' ability to pass on the traditions of responsible gun ownership, shooting sports, and hunting to their children and to their foster children. As I said in my opening statement, a person's rights can never be protected by regulating them. We feel each individual should determine the safe use and enjoyment of guns to be able to protect his family, his property, and enjoy the hunting sports. We feel that once they've gone through all the background checks and everything necessary to become a responsible foster parent, they should be responsible enough to determine how the guns should be taken care of with their children. Thank you.
No questions. Thank you. Representative DeAnda.
Thank you, Mr. Chair, and thank you, committee, for hearing our perspective from the 110th District. These are my constituents also, and I appreciate Senator Casperson bringing this to light because it's a shame that we have to, again, go into legislation. They bring back common sense, and I'm from an area that it's all about common sense. I just want to make a couple of points on this that, I feel very strongly, that's why I came to testify here today, that we see this so much that a lot of these agencies controlled by the state of Michigan have a big outreach when it comes to our personal freedoms. And I'm here today to testify that, this group has to have the oversight along with looking at these bills to be able to come up with what's going to be best for our people. And I'm here to speak on behalf of my people from 110th District. When we have departments that are making policies that are changing our lives, it's not very well for us anywhere in the state of Michigan. Mr. Chair, I really appreciate you taking a look at this issue, and you know it personally. But where does it end? Where does it end in the state of Michigan when we can have the Department of Human Services start making policies that affect all of our lives? What is next? Is the next thing going to be that these foster parents would not be able to be intimate on the weekend if they choose to be? I think this is the question that we all have to think about when things come together, when we start looking at these policies. My disappointment also is the fact that it comes from the executive office also, and I don't care who's in that seat. I think that, you know, there has to be more involvement with the executive office to be able to look at the policies that are made in not just this agency, but the rest of them. These things could be done overnight with a phone call to be able to stop some of these bad policies that we have, just like this gun issue that we're having up in Ontonagon County. We got great people that want to help these kids. They want to be able to raise them in a loving home. They want to be there for these folks to build a better life in Michigan. And if we're going to have departments that are going to start telling us the way people are going to live, God help us all. So thank you for hearing what I had to say from the 110th perspective. Mr. Chairman, thank you very much. Committee members, thank you.
Okay, and we're last to testify. We have MDHHS, Christine Ragan and Stacy Bladen.
Good afternoon, Senator Jones. It's a pleasure to be in front of you again. You are uniquely qualified, given your experience with your own family of foster children and your history of being a sheriff, to entertain this bill. I just wanted, Christine's going to testify, but I just wanted to make a couple remarks related to some things that were said, just to provide some clarity around two things. In particular, we have what's called a prudent parent standard, and you may be familiar with that in child welfare, and that was an attempt really by the federal government to normalize experiences for kids placed in foster care as much as possible so that they can experience all the things that kids experience in their own homes, like sleepovers. And one of those would be things like hunting. So we would certainly support that, encourage it, and our policy wouldn't prohibit that. We encourage foster parents to engage in all of those activities, including hunting, that other children would engage in. And the other thing that I wanted to correct was the allowability of, say, a sheriff to carry a gun in his own home, and that is allowable. Under current policy, that would not be precluded. So those are just two quick things. I want to recognize Senator Casperson for his recognition of the unique needs of kids that come into the foster care system. Many of them have trauma histories. Many of them come from very violent homes. Many children are unable to regulate in the same way that children who are brought up normally regulate themselves, and that can result in them becoming impulsive and not having good decision-making abilities like we would expect normal children to have. And so when we do have kids in foster care, we are very mindful of their trauma histories and their special unique needs, and we accommodate those. So the department has a very serious and significant role to play in that we take children from their own homes and place them into foster homes, and with that comes a significant responsibility on our part. We have care and supervision of those children legally, so the department is legally responsible for them to assure that all of their needs are met and to assure that they're safe. And so we do everything that we can in terms of service provision, in terms of selecting foster homes, in terms of assuring that the environment is safe. And as soon as that doesn't happen and a child is injured, we certainly will be blamed for it. And we will have a very heavy heart if something happens to a child in foster care. And so I just, we are certainly open to additional tools that folks might believe are necessary to better care for kids in care. We certainly look to the legislature and others for your expectations of us in terms of our responsibility to take and care for kids in foster care. And that is our priority focus at the department. So with that, Christine Rehagen is our Director of Child Welfare Licensing and has some special expertise and I think just has a couple things she wants to say. Thank you.
Thank you very much. It's good to be here this afternoon. I won't take a lot of time because Stacy has eloquently discussed pretty much our position and our concerns regarding the bill. We are responsible for the care and supervision of over 13,000 children in the state of Michigan who are placed within our child welfare system. The Division of Child Welfare Licensing takes their safety and well-being very seriously. And as a result of that, we look forward to working with the legislature on potentially tweaking some of the language so that our staff and our private partners can sufficiently regulate and make sure that children are safe in the foster homes that are licensed by the state of Michigan.
I certainly agree with you that in some cases, the experience I had as a foster grandpa, some of the children never, ever would be the type to go hunting. They were mentally handicapped from the horrible abuse they had suffered. But there were some A, B students that were remarkable, and had my child had them longer as foster kids, I would have asked if it was okay to take them hunting because they had expressed a desire, and good kids. And they're now doing very well in the community and attending college, and we're pretty proud of them. So do we have any questions? Seeing none, thank you for your time.
Thank you.
Okay, the sponsors are going to invest some more time in this bill, and we'll go on now to the next bill. Senate Bill 471, Senator Prose.
Good afternoon, Mr. Chairman. Appreciate the opportunity to bring up Senate Bill 471 before you all related to Youth Challenge. I'm not sure how familiar you folks are with Youth Challenge, but it is a unique program that the Michigan National Guard is a participant in and runs through their organization, an organization, of course, that we all appreciate very much in our state. 140 slots approximately per year are available for students who have found themselves in the criminal justice system. They're very unique individuals who are eligible because they would in fact be juvenile offenders who, because of certain offenses, could be eligible. Not all offenders are in fact eligible for this particular Youth Challenge Academy, which is a highly intensive residential academy for 16 through 18-year-olds. The academy itself is 17 and a half months long. It's a two-phase program that incorporates 8 core elements to encourage physical, mental, and moral development. Problem is, the state of Michigan does not allow for expungement of one's record as a juvenile under this particular scenario, having completed this very challenging Youth Challenge Academy. The National Guard came to me recognizing that we had all worked cooperatively, many of you as sponsors of bills related to criminal justice reform in this last few months of effort in the legislature. There are 28 states, including Puerto Rico and the District of Columbia, that operate some 40 programs. Most every one of those challenge academies under the same sort of scenario have at least some opportunity for those particular individuals to have their records expunged from that the offenses that sent them there in the first place. There are significant statistics, as you might imagine, on success in the program itself. Our own Supreme Court has opined upon this as a good thing, that we in the state of Michigan, in fact, ought to be considering this. I should amend that statement. One of the justices opined upon that individually and as a justice on the Michigan Supreme Court for the benefits of expungement of a juvenile's record. We have lots of legislation related to expungement. but this one is very narrow. It does not allow for individuals who are convicted of assaultive crimes, as defined by our code, to be included in this. So I want to make sure that we understand that this isn't overreaching. It's not changing case law to such a significant degree. Instead, it is recognizing what we have right now, which is an inability for those youth who complete this very challenging 17.5-month investment in their future to have that stricken from their record and the opportunity for them to begin again. So, Mr. Chairman, if there are questions, I'd be happy to answer them, but I do believe that this National Guard Youth Challenge program is one that requires a little bit of extra help on our part in the legislature to allow what most every other state provides for, which is an expungement of their record. Thank you, Mr. Chairman.
I'm very familiar with the program. I think it's excellent. I've had many, many parents come in and talk about how successful it was with their child. Do we have any questions? Seeing none, I'll make a motion to report Senate Bill 471 to the floor. Recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca?
Yes.
Senator Colbeck? Yes. Senator Bida?
Yes.
Mr. Chairman, there are 5 yeas and 0 nays. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. Thank you. We'll now move on to Senate Bill 52, Senator Bida and Bill Valancourt from the Prosecuting Attorneys Association.
Thank you, Mr. Chairman. Thank you, colleagues. Decided I would join you from this perspective. I've never really seen it from this perspective before. This bill may seem similar to you. Actually, November of 2016, we unanimously voted a similar bill out. At the time, there were some reservations and concerns that were brought up by a number of groups. Since that time, and several of you on the committee have been part of the work group, along with prosecuting attorneys, the criminal defense attorneys, the Michigan Attorney General's Office, the National Children's Alliance, the MDHHS, Domestic and Sexual Violence Prevention and Treatment Board, participated in a work group that went approximately about 8 months. This bill would remove the statute of limitations for the sexual abuse of a child under 16 involving second-degree criminal sexual conduct. Senate Bill 52 also increases the length of time prosecutors have to file an indictment for a third-degree criminal sexual conduct to 20 years after the offense or the alleged victim's 31st birthday, whichever is later. The sexual exploitation of children, a very repulsive, heinous crime, should not have an arbitrary time limitation for a victim to receive justice. State laws should promote and encourage victims to make a report whenever they are ready. Research indicates that survivors experience depression, anxiety, and drug and alcohol problems which can last a lifetime. Yet the abuser escapes prosecution because of a date reporting loophole. Senate Bill 52 amends the Code of Criminal Procedure by removing the time-barred indictment for second-degree criminal sexual conduct with a child under 16 years of age. This indictment may be filed at any time. Current Michigan law is 10 years or until the victim reaches his or her 21st birthday for second or third degree. Numerous studies tell us that children cannot understand what or why something has happened to them. It takes decades for them to talk about the incident, and by then the abuser has escaped justice under our current statute of limitations laws. And as I mentioned before, we had voted out a similar bill in November of 16. This present bill actually reflects a lot of the concerns that were brought up at that time, and I believe we've addressed those. And with that, I would like to pass this over to Livingston County Prosecuting Attorney, who was part of the work group, and appreciate his testimony as well.
Thank you, Senator. First of all, I just want to thank the Senator. We appreciated the opportunity to work with him, his staff, and others that are involved in the criminal justice system on this bill. It was a cooperative effort, and I think that the product we've come up with represents a positive step to helping to protect victims of child sexual assault and those that might be reluctant to come forward, and we're in support of the bill.
Very good. See, no questions. Thank you. We know this topic well.
Thank you.
Brian Dare from Holland.
Good afternoon. Good afternoon, Chairman, committee members. Thank you for allowing me to be here today and tell my story about my past, my experiences with child sexual abuse. I'm a survivor of child sex abuse, and it took me 34 years to finally tell someone in 2014. The toll it has taken on my life has been plenty, which includes divorce, not having healthy relationships, being locked up for my drinking, living in fear my whole life because of the abuse. Eventually, counseling has saved me and helped me to get my life back on track, but it's a daily struggle. I reached out when I first started researching my past. I reached out to a childhood friend. His name was Brad White. That was back in 2014. After speaking with Brad on the phone, we confirmed that we were sexually abused by the same person. Brad spent 20 years in prison for drug charges and actually ended up killing someone in prison with drugs. Brad and I lived kind of a block away from each other, and our lives were parallel with the same type of abuse being done to us. The person that abused us was Randall Doctor. Randall Doctor admitted to the child sex abuse to many boys, but he cannot be charged for first-degree criminal sexual conduct because of the 2001 statute of limitations that's in place. This bill, Senate Bill 52, does not help my case. However, I support this bill as a step in the right direction to protect children of this state from predators and pedophiles being able to live in our communities still. Many of the victims that I spoke with, if not all of them that I reached out to in our case back in 2014, either had drug or alcohol addictions, depression, and many other issues in their lives. This is just a normal behavior of a person that's been abused. It's, as you can tell, listening to the foster parents, abuse is a lifelong struggle. We had hopes and dreams as boys growing up, and then our souls were destroyed, and our lives took many different directions due to the abuse. However, putting a timetable on criminal charges against a child sex abuser still allows them to be free in our communities. For example, Randall Doctor's in prison for felony gun and drug charges, and he'll be released in a couple years. And that's one of the fears we have. This guy's going to be in our communities again, free. My friend Brad White, who I reached out in 2014, couldn't be here today. Trust me, he would be here if he could have been, but Brad died in a bad car accident earlier this year and took his life. Brad had addiction issues. He'd normally admit it to everyone here. He struggled. And it was his death, as I totally believe, was a direct result of his sexual abuse that started at the age of 11 or 12 years old. We need to pass Senate Bill 52 for the sake of all children here in the state of Michigan, to prevent any more lives being lost because of the abuse that took place in someone's childhood. Victims need to have justice for what was done to them, and we need to quit protecting the abusers in this great state of Michigan. Thank you for allowing me to be here. I'll take any questions if you have any.
Thank you for making the trip and telling this very personal, tough story. I know it's got to be hard, but hopefully this time we can get this all the way through and make an improvement in our law. Do we have any questions? Seeing none, thank you very much. Connie Nesberry from Muskegon.
Members of the committee for allowing me to speak to support Senate Bill 52. And I also want to thank Senator Beda for inviting me to serve on the work group committee this year. My name is Connie Nesberry, and I have been a licensed professional counselor and a limited licensed psychologist in the state of Michigan for over 2 decades. I'm also a STAR behavioral health provider clinician trained to work with military. My expertise is in post-trauma recovery, and I've worked with hundreds of survivors and veterans over the years. RAINN statistics, and RAINN is the Rape and Incest National Network, report that an American is sexually assaulted every 98 seconds, and every 8 minutes that victim is a child. Meanwhile, out of every 1,000 rapes, only 310 are reported Only 7 offenders are prosecuted, and only 6 are incarcerated. And then sometimes, as Brian pointed out, they have short sentences. According to the Crime Victim Center, 1 in 3 girls and 1 in 6 boys are sexually assaulted before the age of 18. It's estimated that there are over 60 million survivors of child sexual abuse in America. Consequences for victims include high rates of depression, anxiety, substance abuse, dissociative disorders, interpersonal dysfunction, sexual problems, and suicidal ideation. And I want to make note that this month is Suicide Awareness Month. The moment someone is penetrated without consent, relationships are destroyed, many times beyond repair. In an instant, it changes the trajectory of your life. Many child sexual abuse survivors don't remember until well into their 30s, 40s, or beyond, but these incidents can then remain vivid until there is some resolution. Senate Bill 52 will allow more survivors to have the ability to come forward and heal, so I strongly support this bill. But please know that the consequences from abuse alone are barriers enough that prevent victims from reporting. Victims don't need legislative barriers as well. I encourage you to consider Reign's position that there be no statute of limitations on child sexual abuse for 2nd and 3rd degree. All survivor stories need to be welcomed to put an end to the pandemic in this country of sexual assault. I recently produced a 4-hour radio documentary entitled Criminal Sexual Conduct, What Needs to Change. You have a press release on that. From the 22 interviews that I recorded, it was made very clear to me that our system is broken, and I interviewed people from all across the country. Blaming and shaming of victims and offenders needs to stop. Education and awareness is vital. Shifting our culture and language to one of respect and equality for all will remove the dehumanizing excuses for abuse. Offenders need to be stopped, but then we need to be able to focus our efforts on offender treatments in a way that's not shaming and that clearly defines what is appropriate and inappropriate behavior and what consequences and reparations are due. I understand that eliminating or extending the statute of limitations generates a fear that more people will be accused, create more prosecutions, trials, lawsuits, cost more money. I need to address this. 1, it costs us all far more in mental health, substance abuse treatments, social services, and medical care working to heal the victims from an offender than it does to incarcerate one. On top of that is lost wages and productivity and the loss to society of skills and talents of all parties. There's a huge cost from loss of life, as many who commit suicide are those who feel they are not heard and feel hopeless. 2, prosecutors and attorneys don't take cases, whether civil or criminal, without evidence. To say that many people may be unjustly prosecuted is an excuse, and I would think an insult to those in the legal profession. 3, the most important reason for you to support Senate Bill 52 is that all children deserve to be safe. Allowing for criminal prosecution is the only way to accomplish that in our current system. Please ask yourself, who do I need to protect, and support Senate Bill 52, which will extend protections for children and survivors of criminal sexual conduct. I applaud the courage it takes for you to deal with these issues that all of us wish did not exist. Thank you.
Okay, seeing no questions, thank you. Aviva Woodward from Gregory.
Hello. Some of you might recognize me. I've done this before. My name's Aviva Woodward, and I'm a survivor of childhood sexual abuse. I spoke to you last fall in defense of the now dead House Bill 5859, I believe it was, to lift the statute of limitations on child sexual assault. And some of you were given a copy of my story by Senator Bida's office. Now I'm back to ask you to do what you can to see Bill 52 pass. I realize there are some heavy hitters like the Catholic Church opposed to lifting the statutes of limitations that are in place, but continuing with these archaic limitations involving crimes against children only protects the offender and allows them to go on re-offending and laying waste to generations of children in their lifetime. My mother met my former stepfather, not surprisingly, when he was a camp counselor at the youth camp I attended, and is now a prominent faculty member at Yale, still surrounding himself with young people. Allowing child predators like my former stepfather to roam free and unidentified amounts to nothing less than a public health crisis. The price tag of convicting these predators pales in comparison to the price they have left behind. Statistically, their victims, like we just heard from the last statement, statistically, their victims will go on to suffer from mental illness, substance abuse, and other costly behaviors, possibly even becoming predators themselves. I keep a letter, this is a copy of it, that my former stepfather wrote in 1994 in hopes of saving his marriage to my mother, confessing to sexually abusing me starting at the age of 11 and then moving on to my sister. I ask that you give me back the power he stole and allow me to use this and other evidence to stop him from hurting other children. Thank you.
Thank you for your very tough testimony and coming in today. And I think a lot of work has been done on this one, and I think this will have a lot better chance of making it all the way through.
Okay.
Thank you. Do we have any questions? Seeing none, thank you very much.
Thank you.
Okay, I'll read in the cards and we'll vote. Gene Doss, Michigan Coalition to End Domestic and Sexual Violence, in support. Debbie Kane, Michigan Domestic and Sexual Violence Prevention and Treatment Board, in support. Sergeant Tim Fitzgerald, Michigan State Police, in support. Josh Robertson, Michigan Chapter of the National Children's Alliance, in support. John Shea, Criminal Defense Attorneys of Michigan, neutral. I'll make a motion to adopt the S2 version of Senate Bill 52. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Senator Rocca?
Yes.
Senator Colbeck? Yes. Senator Bita?
Yes.
Mr. Chairman, there are 4 yeas and 0 nays. The substitute is adopted.
I'll make a motion to report the S2 version of Senate Bill 52 to the floor with the recommendation the bill then pass. Madam Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Senator Rocca?
Yes.
Senator Colbeck?
Yes.
Senator Bita?
Yes.
Mr. Chairman, there are 4 yeas and 0 nays. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. It should be noted that Senator Shoemaker is in support of this bill, but she had to leave for a meeting with the governor. I'll make a motion to excuse absent members. Without objection, absent members are excused. No further business. We are adjourned.